Have you ever entered into a contract only to then discover that there was a misunderstanding? In contract law, we call that a mistake. So, what then happens to the contract? To encourage us to make more videos like this, please like, share and subscribe. We will really appreciate it. Thank you. A mistake in contract law is a misunderstanding or erroneous belief about a matter of fact. In common law, there can be three different types of mistake: unilateral mistake, mutual mistake, and a common mistake. A unilateral mistake is where only one party has made a mistake of fact. For example, A is selling Arabic coffee, whereas B accepted the offer thinking that he is buying Turkish coffee. In such a situation, the contract is void as there is no adjoining link between the offer and the acceptance. A mutual mistake is, as the name suggests, where both parties made the mistake and are at cross purposes. For example, A agrees to sell and B agrees to purchase coffee on a cargo ship owned by A that was supposed to set sail from Hong Kong to Malaysia on 20th February. B later discovered that A actually owned two ships that set sail from Hong Kong to Malaysia on that day. B thought that he was buying coffee transported in a ship that looks like this, and A thought that B agreed to buy coffee transported in the other ship. In such a situation, the parties were talking to each other like that. The contract is then void as no agreement would have existed as the parties were referring to different ships. Common mistakes, unlike mutual mistakes, is where both parties made the same mistake without being at cross purposes. For example, A agrees to sell and B agrees to purchase a factory in Penang that produces coffee. However, on the day before the signing of the agreement, the factory was destroyed by a fire which both the parties were not aware of. In such a situation, the contract is void as the mistake has the effect of nullifying the consent. Had both the parties knew about the fire, they would not have agreed to the contract. Yes, I love drinking coffee and talking about the law. And I digress. Notwithstanding the common law position, in Malaysia, not all mistakes will render the contract void. In Malaysia, Section 21 of the Contracts Act 1950 states, where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. This applies to situations where the mistake is both mutual and common. What is important to note is that the mistake of fact has to be one that is essential or fundamental to the agreement. If it is not, the contract would most likely still subsist. Section 22 of the Contracts Act 1950 states, a contract is not voidable because it was caused by a mistake as to any law enforced in Malaysia. But the mistake as to a law not enforced in Malaysia has the same effect as a mistake of fact. Ignorantia legis neminem excusat, which means ignorance of the law excuses no one. In other words, ignorance of the law is not a ground to terminate a contract. However, if the parties enter into a contract thinking that a particular law exists but in actual fact it does not, and the non-existence of the law would render the contract invalid, then such contract will be deemed void. Section 23 of the Contracts Act 1950 states, a contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. If the contract is clear, unilateral mistake will not affect the validity of a contract because a contracting party is expected to understand what is stated in the contract and take reasonable steps to ascertain what he is contracting about. Sometimes, a misunderstanding can be mistakenly took or mistook as a mistake. Pun intended. It is however not that clear-cut. Whether it will render the contract void or voidable will really depend on the nature of the mistake and the facts of each case. So, which type of coffee do you prefer? Arabic, Turkish, or Tenom coffee?